Okay, let's unpack this. Welcome to the deep dive.
Glad to be here.
Today, we're wading into a really fascinating, sometimes, well, messy, corner of private international law.
Definitely. It's known as conflict of laws.
And we're going to explore how English law navigates personal relationships,
Hmm.
things like marriage and the status of children when those relationships cross international borders and potentially involve different legal systems.
It gets complicated fast.
Now, this deep dive is built upon the incredible educational materials generously made available by the University of London.
Yes, a huge thank you to them for making these valuable resources accessible.
Absolutely. And please remember, everyone, the content we're discussing is strictly for educational purposes only.
That's right.
To everyone using this material for your studies, especially if you're preparing for exams, we wish you the very best of luck.
Yes. Good luck. We really hope this deep dive helps make these complex points clearer and maybe a bit more memorable for you.
And this deep dive is brought to you by Sinorbit Academy, Sri Lanka. We're grateful for their support in bringing this material to you.
Okay, so where do we start?
Well, the fundamental problem we're looking at arises because, people don't stay put. They move, they travel, they form relationships with people from other countries.
They might marry somewhere that isn't their home or have children while living abroad and then maybe move again.
Exactly. So when the laws of the different places they're connected to, their domicile, nationality, or where they got married, have conflicting ideas about, say, whether that marriage is valid or whether a child has a certain legal status.
The big question is, how does an English court decide?
That's our mission today, to cut through that complexity and understand the specific rules English courts use to answer these questions, which country's law applies.
That's exactly right. It's about providing a framework, a way to resolve these potentially very human, very challenging situations that arise from international connections.
So what are the main areas we'll hit?
We'll be focusing on the validity of marriage, which has two main components: the formal requirements of the ceremony itself,
Right, the how.
and the essential validity, the parties' fundamental capacity to marry each other, the who.
Okay.
And this leads us into fascinating areas like how English law grapples with potentially polygamous marriages and the newer landscape of same-sex marriages in a conflict of laws context.
And children.
Yes. Finally, we'll look at the legal status of children, particularly issues of legitimacy and legitimation. These can still have significant consequences in certain legal scenarios in England, even if the domestic concept of illegitimacy has, thankfully, largely faded in importance.
We're drawing directly from a comprehensive document that lays out the key rules, the underlying principles, and crucially, the essential case law that has shaped this area.
Yes, the cases are vital.
So think of this deep dive as your guided tour through those materials, highlighting the most important nuggets you need to understand to master this topic, and of course, feel confident walking into that exam room.
Let's dive in.
Let's start at the beginning. The nuts and bolts of the ceremony itself. How does English law determine if the wedding ceremony, wherever it took place, was formally valid?
Okay. What's interesting here is that English law starts with a very clear, very firmly entrenched rule for the formal validity of a marriage.
A foundational rule.
Yes. This rule is called the lex loci celebrationis. You should remember that term. Lex loci celebrationis.
Lex loci celebrationis. Okay, got it. So that literally means the law of the place where the marriage was celebrated.
Precisely. The fundamental principle is pretty straightforward, actually. If you get married in a particular country, the formalities of the ceremony.
Like how it's performed, witnesses, the building.
Exactly. How it's performed, the witnesses required, the type of building, maybe the documentation needed right there at the ceremony.
Yeah.
All those things are governed by the law of that country, and only that country.
It sounds simple enough in theory. You just follow the rules of the country you're in for the ceremony. But I'm guessing different legal systems might see the same requirement differently. That could lead to complications.
You guessed right. This leads us straight into what we call characterization problems.
Characterization.
Yeah. While English law has its own classification of what is a formal requirement versus an essential requirement, which, remember, goes to the party's capacity to marry a foreign legal system, might classify the same thing differently.
So the English court has to decide how to label the foreign rule.
Exactly. Based on English standards, the court has to characterize that foreign requirement when applying the lex loci celebrationis.
Can you give us an example from the source material of how this characterization issue plays out?
Sure. A classic and really important example is the issue of proxy marriages.
Where someone isn't actually there.
Right. English domestic law, generally, requires both parties to be physically present for the ceremony. However, some other legal systems, particularly in parts of South America, permit marriage by proxy, where one or both parties are not physically present, but are represented by someone else.
So the characterization question is the requirement of physical presence about how consent is expressed or delivered during the ceremony, which would be formal?
Or is it a requirement that goes to the fundamental fact that consent is being given at all? Or maybe the party's basic capacity,
Mm.
which might sound more essential.
Okay, that's a tricky distinction.
It is, and it's the crucial distinction English courts have had to make. In the well-known case of Apt v. Apt, decided back in 1948, the court squarely faced this issue.
Apt v. apt. What were the facts?
It involved an Englishwoman who had married an Argentinian man by proxy in Argentina. The marriage was perfectly valid under Argentinian law, the lex loci celebrationis.
But the question was whether England would recognize it, given England's own rule about needing to be present.
Precisely. And what the court in Apt v. Apt decided was key. They classified the requirement of physical presence not as a matter of essential validity, not about the fact of consent, but as relating purely to the method of giving consent at the ceremony.
Ah, so the how.
Exactly. Since it was a matter of method, it was a formal requirement. Therefore, it was governed by the lex loci celebrationis, which was Argentinian law.
And Argentinian law allowed proxy marriages.
Yes. So the marriage was held to be formally valid in England, even though the bride wasn't physically there in Argentina. This established that for English law, presence is generally seen as a formality governed by the place of celebration.
Okay, so Apt v. Apt confirmed that English law treats presence at the ceremony as a formal issue, subject to the lex loci celebrationis. You need to remember Apt v. Apt.
Yes, and this principle was reinforced in later cases, like Paz Pena de Vera v. Paz Pena de Vera, which involved a Uruguayan proxy marriage. But probably the most striking illustration of how far this can go is McCabe v. McCabe in 1994.
McCabe v. McCabe. What happened there? That sounds even more extreme.
It really was quite striking. This case involved a marriage in Ghana under customary law. The key fact was that neither spouse was physically present in Ghana for the ceremony. They were both in England.
Neither of them. How did that work?
Well, the customary ceremony reportedly involved the groom providing a drink to the bride's family, and their acceptance constituted the marriage ceremony under Ghanaian law.
Wow. And the English court said?
The English court upheld the formal validity of this marriage. Why? Because it satisfied Ghanaian law, the lex loci celebrationis, despite the complete lack of physical presence of the parties at the ceremony location in Ghana.
That really underscores the strength of the lex loci celebrationis rule for formalities. It's all about the law of the place.
It absolutely is.
What about something like parental consent for minors? Where does that fit in? Is that form or substance?
That's another good example of characterization. English domestic law requires parental consent for individuals aged 16 and 17 to marry, but crucially, if they marry in England without that consent, the marriage is still valid.
So England treats its own consent rule as formal.
Yes, the lack of consent is treated as a matter of form, not something that affects their capacity to marry. And when English courts encounter foreign rules requiring parental consent, they generally characterize these rules in the same way as matters of form.
And this sounds like it connects to a well-known foundational case, Ogden v. Ogden.
It does indeed. Ogden v. Ogden from 1908 is a landmark case in conflict of laws, probably one you've encountered before. It's relevant here for characterization.
Remind us of the basics in Ogden.
It involved a marriage celebrated in England between an English-domiciled woman and an underage French national. French law required parental consent for him to marry, and he didn't have it.
So under French law, he maybe lacked something important.
Yes, but the English court treated the French rule requiring parental consent as a requirement of form.
Ah, so because the marriage took place in England, the lex loci celebrationis was English law.
Correct. And since English law classifies lack of parental consent for a minor as a formal matter that doesn't invalidate the marriage was held to be formally valid in England.
Even though it might have been invalid in France under his personal law regarding consent.
Exactly. Lodge v. Lodge in 1963 is another case cited as following this approach. It illustrates vividly how English law applies its own characterization standards when applying the lex loci celebrationis.
Okay, so Ogden v. Ogden reinforces that foreign parental consent rules are generally treated as formal by English courts. This lex loci celebrationis rule seems incredibly dominant for formalities. How strong is it, really?
It is, as the source emphasizes, firmly entrenched. Another classic illustration of its dominance is the Privy Council case Berthiaume v. Dascos from 1930.
Berthiaume v. Dastu. Tell us about that one.
This involved a couple who were both domiciled in Quebec, Canada. They got married in a Roman Catholic church in France.
Okay.
But French law at the time required a civil ceremony before a registrar for a marriage to be formally valid. They only had the church ceremony.
So the church ceremony didn't satisfy French legal formalities, but presumably that church ceremony would have been a formally valid marriage back in Quebec under their own laws.
Precisely. That's very likely true. But what Quebec law said about formalities was completely irrelevant. Because the marriage ceremony took place in France, the Lex Loci Celebrationis was French law.
And they didn't follow French law.
No. Since they failed to comply with the required French civil ceremony formality, the marriage was held to be void in English law. It didn't matter that it would have been valid under their domicile law. The rule of the place of celebration governed the formalities absolutely.
And McCabe v. McCabe with the Ghanaian ceremony further reinforces this.
Yes, because there, the marriage was upheld because it complied with the law of the place where the ceremony occurred, Ghana.
So the rule is, comply with the formalities of the country where you get married, or your marriage isn't formally valid in England, regardless of what your home country's law says about formalities.
That's the core principle for formal validity.
This rule seems so powerful, the source mentions it can even reach back in time. Retrospective validation.
Yes, that's one of the most sort of intriguing aspects.
Mm.
The Lex Loci Celebrationis rule is so strong that it can even validate a marriage that was initially void under that very law if that law changes retrospectively to validate it.
Wow. What's the case for that?
The leading example here is Starkowski v. AG, a House of Lords decision from 1954. You should remember, Starkowski v. AG.
Starkowski v. AG. What were the complex facts in that case? Sounds complicated.
It was. It involved Polish nationals who married in Vienna during the Second World War. At the time of the ceremony, the marriage was actually void under the then current Austrian law, which was the Lex Loci Celebrationis.
Okay, so void when it happened.
Right. But later, after the war, Austrian law changed, and legislation was passed that retrospectively validated marriages like theirs. Years after the marriage, the parties were domiciled in England, and the wife actually remarried in England, believing her first marriage was void.
Oh dear. So the House of Lords, applying the Lex Loci Celebrationis rule, retrospectively, held.
The House of Lords held that the first marriage, the one in Vienna, was valid in England. This was purely because it had been retrospectively validated by the Austrian law, the Lex Loci Celebrationis, even though the parties were now domiciled in England, and the wife had entered into what she thought was a valid second marriage.
That must have had some dramatic real-world consequences for the people involved. Legitimacy of children, validity of the second marriage?
Absolutely. The child born of the first marriage was held to be legitimate because that marriage was now deemed valid from the start. However, the child born of the second marriage was rendered illegitimate because the mother was, in the eyes of the law following the retrospective validation, legally married to the first husband when she entered the second marriage.
That's tough.
It is. And it raises challenging hypotheticals, too, like, what if the second marriage had happened before the Austrian law changed? Would the validation still occur and potentially invalidate the second marriage? These aren't just abstract rules. They have profound impacts on people's lives.
Thinking about the power of foreign retrospective laws, what about public policy? You mentioned that earlier. What if a foreign country passed a law that didn't validate but actually retrospectively invalidated marriages that were valid at the time, perhaps targeting certain groups or political opponents? Would English courts recognize that?
That's a critical question, and the source suggests that English courts would likely draw a line here. While retrospective validation by the Lex Loci Celebrationis is accepted under Starkowski, retrospective invalidation of a valid marriage by a foreign law.
Especially if it seemed unfair or discriminatory.
Exactly. That would likely be refused recognition in England on public policy grounds. This highlights that public policy can, in exceptional circumstances, act as an override to prevent the application of a foreign law rule that is deemed fundamentally repugnant to English justice or fairness.
Okay, so the Lex Loci Celebrationis is the default dominant rule for formalities, powerful enough for retrospective validation, Starkowski, but potentially limited by public policy for retrospective invalidation. Are there any other, maybe more general exceptions to this rule?
Yes, there are exceptions, both statutory and common law. The statutory ones are quite niche, dealing with things like marriages on naval ships or in consular offices overseas. The source mentions them, but you probably don't need the detail for most purposes.
Right.
The common law exceptions are more important for our discussion.
And this brings us back to the concept of common law marriage, but specifically in this technical conflict of laws sense, right? We need to be careful not to confuse it with the popular, often incorrect idea of couples who just live together.
Precisely. It's absolutely crucial to understand that distinction. A common law marriage, in conflict of laws, refers to a marriage that is considered valid according to English common law, as it existed before the statutory formalities were introduced by Lord Hardwicke's Marriage Act, 1753.
Ancient history, basically, just consent and presence.
Pretty much, it required simply consent and the presence of the parties.
Okay, so we're talking about these ancient English law formalities. When can this apply today as an exception to the lex loci celebrationis?
There are three situations mentioned in the source where this common law marriage exception might apply. Firstly, where English common law applies extraterritorially, for example, to British subjects in a territory where there is effectively no local law of marriage.
Like the Wolfenden case in China.
Yes, Wolfenden v. Wolfenden in 1946 is often cited,
Okay,
but the source notes there are probably no true surviving examples where this is a pure exception today, as the common law is now essentially deemed the local law for British citizens in such places.
Okay, what's the second situation?
Secondly, where there is insuperable difficulty in complying with the local law formalities. For example, if the only type of marriage ceremony available locally is one that would make the marriage polygamous, and the parties intend a monogamous union.
Makes sense. And the third and perhaps most significant situation.
That is where there is belligerent occupation. This doctrine was extended quite controversially in the aftermath of the Second World War.
How so?
It was used to cover marriages celebrated by members of occupying forces or displaced persons in places like Germany and Italy, where they did not comply with the local formalities of the occupied country.
And the key and controversial case here is Tatsanowska v. Tatsanowski.
That's the one. Tatsanowska v. Tatsanowski, decided in 1957. Remember that name, Tatsanowska v. Tatsanowski.
Got it. What happened?
The facts involved two Polish nationals who were married in Italy during the Allied occupation, specifically in Rome. They were married by a Polish army chaplain, but critically, without complying with the local Italian civil formalities.
But if the rule is lex loci celebrationis, Italian law, and they didn't follow Italian law, why did the court validate it? How could it be a valid common law marriage?
That's the million-dollar question. The court's justification was based on the principle behind the locus regit actum rule that the place governs the act. The court reasoned that this rule is founded on a presumption that parties marrying in a foreign country submit themselves to his laws.
Okay.
They felt this presumption was rebutted when dealing with members of an occupying force, or, as in this case, escaped nationals who were part of an organized military presence and were not considered to be submitting to the laws of the occupied territory.
Okay, so they weren't submitting to Italian law. Fine. But why then apply ancient English common law, law from a country that neither party was domiciled in or seemingly had any connection to? Why not apply their personal law, Polish law?
Exactly. That's precisely the core of the academic and judicial criticism directed at Tatsanowska. As the source quotes Clarkson and Hill, the decision is described as extraordinary.
It does sound a bit strange.
Critics, preferring approaches like the insuperable difficulty test applied in cases like Savenis v. Savenis in Australia, fundamentally question why, if the presumption of submission to local law was rebutted, the court didn't turn to the party's actual personal law, Polish law, instead of conjuring up a pre-1753 English rule.
It sounds like a decision may be driven by a desire to uphold the marriage, but perhaps struggling for a solid legal basis.
That's certainly one interpretation, yes. Tatsanowska has been followed, but attempts to explain it, such as in Merker v. Merker in 1963, by suggesting occupying armies or organized groups of escaped prisoners of war form an enclave where local law doesn't apply. Well, they raise further questions. Like as the source asks, why only escaped prisoners? Why apply pre-1753 English law specifically? The conclusion drawn in the materials is that the law in this specific area, the belligerent occupation exception to lex loci celebrationis, is most unsatisfactory. It remains a highly debated point.
Okay, so we have the dominant lex loci celebrationis rule, with characterization issues, apt, Ogden, retrospective validation, Starkowski, potential public policy limits, and these controversial common law exceptions, particularly Tatsanowska. Does Renvoy play a part in formal validity? that idea of looking to a country's whole law, including its conflict rules.
Ah, Renvoi.
Mm.
The source mentions that in Tatsanowska v. Tatsanowski itself, the court did accept that Renvoi could potentially be relevant.
How so?
The English court considered that Italian law, the lex locis celebrationis, might potentially refer the matter back to the parties' lex patriae, their national law, which was Polish law.
Did it make a difference in the end?
No, it didn't change the outcome in that particular case, because
Mm.
the marriage wasn't formally valid under Polish law either. So while the possibility of Renvoi was acknowledged, it wasn't outcome determinative in Tatsanowska. The source points to academic discussion, particularly in Clarkson and Hill, for a more detailed exploration of Renvoi's potential role here, but it's not a major feature generally.
Right. Renvoi adds another layer of complexity. Good to know it was considered. So, to recap formal validity quickly, the golden rule is lex loci celebrationis, the law of the place where the ceremony took place. Characterization is crucial, seen in cases like Apt v. Apt for proxy marriages and Ogden v. Ogden for parental consent. It's a strong rule, even supporting retrospective validation in Starkowski v. AG. But there are debated common law exceptions, most controversially the belligerent occupation rule from Tatsanowska v. Tatsanowski. And theoretically, Renvoi might have a role, though its application seems limited.
That's a solid overview of the formalities, the how.
Yeah.
Now let's shift gears entirely. We've looked at the how of the ceremony, now we need to look at the who. This is the essential validity of the marriage, the fundamental capacity of the parties to marry each other.
So this is about things like age limits, prohibited degrees of relationship like marrying a close relative, or whether you're already married to someone else. The substance.
Exactly. It goes to the substance of the relationship, not just the form of the celebration. And for essential validity, the key is the party's personal law. This is fundamentally different from formal validity, where we applied the lex loci celebrationis. Remember that distinction. Formal validity is lex loci celebrationis. Essential validity is personal law.
Why the switch? Why isn't the law of the place of celebration used for essential validity too? It seems so dominant for form.
The source provides the clear policy reason. If the law of the place of celebration governed essential validity, parties could easily evade restrictions under their own personal law simply by traveling to a country with more permissive rules.
Ah, the marriage tourism problem.
Precisely. Historically, this was a significant concern regarding issues like minimum age, prohibited degrees, or more recently, the recognition of same-sex relationships when they weren't legal in the party's home country. You could just pick your jurisdiction based on convenience, potentially undermining the policy of your own legal system.
Okay, so personal law is key for essential validity to prevent evasion. But what is personal law in this context? This isn't as simple as nationality for everyone in English law, is it? Domicile, usually.
Correct. In English conflict of laws, personal law generally means the law of a person's domicile. However, when it comes to the essential validity of marriage, deciding which domicile or combination of domiciles is the governing law is a matter of considerable academic and judicial debate. It's not straightforward.
So there are different theories.
Yes, the source lays out several competing proposals or tests for what the relevant personal law should be.
Okay, let's walk through those different tests for personal law governing essential validity. What's the first one? The main contender.
The test that arguably has the most support in academic writing and certain lines of case law is the dual domicile doctrine.
Dual domicile. How does that work?
The rule is that for a marriage to be essentially valid, you must look at the law of each party's domicile at the date of the marriage. The marriage is valid only if both parties have the capacity to marry each other according to their own separate domiciliary laws.
Both must have capacity under their own law.
Yes. If either party lacks capacity under their domicile law at that time, the marriage is void in the eyes of English law.
So, using the source's example, if we have a 15-year-old domiciled in England, where the minimum age is 16, marrying a 15-year-old domiciled in Paraguay, where the minimum age might be lower, and they marry in Paraguay where it's permitted.
Under the dual domicile test, that marriage would be void in English law.
Why?
Because the English domicile party lacked capacity under English law, their domicile law. It doesn't matter that they both had capacity under Paraguayan law, lex loci celebrationis, or that the Paraguayan party had capacity under their own domicile. The test requires both to have capacity according to their own respective domiciliary laws at the time of marriage.
Okay, that seems relatively straightforward and logical on its face. Ties capacity to your home legal system.
It does. Its proponents argue it fits well with expectations. You kind of carry your personal legal restrictions with you. It's also relatively easy to apply, as domicile at the time of marriage is a fixed point in time.
Any downsides?
The main criticism highlighted in the source is that it might not be ideal for couples who marry with a firm intention to immediately emigrate and settle in a new domicile. Their capacity is judged by the law of a place they are about to leave permanently, which might seem disconnected from their future life.
Which leads us directly to the next proposed test, the intended matrimonial home doctrine. That sounds like it addresses the immigration issue.
Exactly. This doctrine was strongly championed by the influential academic Cheshire. As he formulated it, the rule suggested a presumption that the capacity to marry is governed by the husband's domicile at the date of marriage.
Uh-huh. Bit traditional sounding.
Yes, it reflected the historical context, where a wife typically acquired her husband's domicile and they lived where he did. The source notes that today, if there was such a presumption, it might logically favor dual domicile instead.
But the core idea wasn't just the husband's domicile.
No, the key part was that this presumption could be rebutted if the parties had a definite intention to set up their matrimonial home in a different country, and they actually carried out that intention by moving there within a reasonable time.
So the law of where they plan to live together governs their capacity.
That's the core idea. The law of the place where the couple plans to live together, where their marital life will actually unfold, should be the law that determines if they have the fundamental capacity to enter into that relationship. Proponents argue it's the most sensible rule for couples who marry specifically intending to live in a new country and sever ties with their former domiciles.
Okay, that makes some intuitive sense for those specific cases. But the source lays out significant detailed criticisms against the intended matrimonial home doctrine, often pointing to practical difficulties. What are some of the key problems?
There's several major issues. Firstly, it's a retrospective test. You have to wait and see if the intention to move is actually fulfilled.
What if something goes wrong?
Exactly. What happens if they intend to move to country X, but one party becomes ill, or there's a war, or they just change their minds and they never make it there? Does the validity of their marriage, which was fixed at the date of celebration, suddenly shift based on a future event that didn't happen?
That sounds incredibly uncertain.
It is. The source uses the stark example of the boat sinking before they reach their intended home. How is the marriage's validity determined then? It injects a huge element of uncertainty into a fundamental status.
Uncertainty seems like a recurring problem with this test, then.
It is. What if they change their mind about where to live after the marriage? What if they move several times? Is the validity of the marriage constantly being reassessed based on their latest move or intention? Critics argue this makes the validity of a fundamental status like marriage far too fluid and unpredictable.
And problems with proof must be considerable. How do you prove intention?
Absolutely. How do you definitively prove someone's subjective intention at the date of marriage? How quickly does that intention have to be acted upon to be considered within a reasonable time? How long do they have to live in the new country for it to count? Do they need to acquire a new domicile there? These are all difficult, fact-specific questions without clear legal standards, adding to the unpredictability and, frankly, the litigation risk.
And the source highlights that this doctrine can lead to uncomfortable conclusions. What kind of conclusions?
Yes, conclusions that feel intuitively unfair. Consider the scenario provided. A 13-year-old from England who marries in a country where that age is permitted, with the genuine intention of staying there permanently. Under the intended home doctrine, that marriage might be valid because it's valid under the law of their intended home, the foreign country. Okay. Now contrast that with a 13-year-old from Nigeria marrying there, where it might also be permitted, but with the intention of coming to live in England. Under the intended home doctrine, their emigration to England could potentially invalidate a marriage that was valid where and when it took place, because English law, the intended home, wouldn't permit it.
And that second scenario, involving immigrants, is probably more common.
Much more common, yes. And invalidating such a marriage years later feels harsh and unjust. The source argues the doctrine injects too much uncertainty and can lead to these perceived injustices.
So, while the intended matrimonial home doctrine has some theoretical appeal for specific immigration cases, its practical difficulties and potentially unfair outcomes make it highly contested. What about the real and substantial connection test? That sounds quite flexible.
It's another approach that has received some limited judicial and academic support. It proposes that the essential validity of a marriage should be governed by the law of the country that has the most real and substantial connection to the marriage.
How do you measure that?
Well, this country might often be the matrimonial home, but the test allows for considering other factors like the parties' domiciles or nationalities, weighing them up to find the strongest connection.
Did any specific judicial figure favor this?
Lord Simon gave it some support in the case of Verveke v. Smith. Remember Verveke v. Smith? He suggested it might be appropriate for issues of quintessential validity or those closely touching on public policy, like whether a marriage is a sham or a marriage of convenience.
So maybe for specific types of validity issues.
Perhaps. But what's the primary criticism of this test as a general rule?
The main criticism is that it's just too vague and unpredictable. As critics put it, it question begs. It doesn't really provide a clear rule. It simply restates the problem by asking you to find the most connected country.
It leaves a lot to judicial discretion.
Yes. Determining which country has the most real and substantial connection is a subjective exercise left to the court's discretion in each case, which again introduces undue uncertainty into the law governing a fundamental personal status like marriage.
Okay, so dual domicile is clearest, but maybe rigid. Intended home is flexible, but uncertain and potentially unfair. Real connection is vague. What else is proposed? The alternative reference test.
Yes. This approach is less about identifying a single governing law and more about achieving a desired outcome specifically, validating the marriage as possible.
How does it do that?
It suggests that a marriage should be held valid if it is recognized as valid under either the dual domicile test or the intended matrimonial home doctrine. It essentially gives the marriage two shots at validity.
That sounds pragmatic, maybe. Has it been used?
It has received some support in cases like Lawrence v. Lawrence. However, critics, including the Law Commission and academics like Jaffe, have rejected it quite strongly.
Why? Validating marriages seems like a good goal.
They see it as an abdication of the quest for a rational choice of law rule. It's viewed as conceptually weak because it doesn't articulate why one rule should govern over another. It just says, pick the one that validates, which isn't really a principled choice of law approach.
I see. And the source also mentions and dismisses the idea of validity under either party's prenuptial domicile.
Yes, that's quickly dismissed. Like the alternative reference test, it aims for maximum validation by saying a marriage is valid if valid by the domicile of either the husband or the wife at the time of marriage.
But the problem there is evasion.
Exactly. It's heavily criticized because it would allow parties to easily evade restrictions under their own law by marrying someone from a country with more lenient rules, and it could lead to limping relationships.
Yeah.
Marriage is considered valid in one country but not another, creating significant legal confusion.
Okay, so lots of different tests, all with problems. Given all these competing theories and their respective criticisms, the source raises a really interesting question. Why assume we need a single rule for all aspects of essential validity? Could different issues be governed by different rules?
A variable rule.
Yes, the concept of a variable rule. This idea was suggested by Cumming Bruce J. in Radwan v. Radwan, number 2, which is a really significant case we'll examine closely when we discuss polygamy later.
What did he suggest in Rad 1?
He suggested that perhaps the capacity to enter a polygamous marriage might be governed by one choice of law rule. He favored the intended matrimonial home for that specific issue, while other capacity issues like age restrictions or prohibited degrees of relationship might still be governed by the party's domicile.
That sounds logical on one level, different issues, different connections. How has this idea been received academically? Is there consensus?
Opinion is sharply divided. Academics like Cheshire, North, and Fawcett are described as scathing, arguing that a variable rule would lead to uncertainty, anarchy, and injustice. Basically, chaos.
Strong words.
But by contrast, Clarkson and Hill suggest it has much to commend it. They argue it fits with an interest analysis, recognizing that different policies underlie different types of incapacity rules.
Can you give an example?
Sure. Minimum age rules are primarily about protecting minors, suggesting a strong link to their personal law, domicile, whereas rules regarding polygamy might relate more to the social structure and expectations of the community where the couple intends to live, suggesting a link to the matrimonial home.
So different rules make sense depending on the underlying policy.
That's the argument. Academics like Hartley, Jaffe, and Davey have contributed to this ongoing debate.
So it's clear there's no single universally accepted rule for essential validity, though the dual domicile test arguably has the most general support despite its potential drawbacks in some situations.
Exactly. It's a contested area.
Yeah.
And to make things even more complicated, there's a very important exception or modification to whichever general rule you might favor for essential validity. An English exception.
Ah, yes, I remember reading about this. What's this key exception?
Okay, listen carefully to this one. If a marriage is celebrated in England, and at least one of the parties is domiciled in England at the time of the marriage, English law governs the essential validity. Any invalidity under the foreign domicile law of the other party is effectively ignored.
Wow, that's a strong carve-out for marriages happening on English soil, particularly when an English domiciliary is involved. It seems to prioritize English law quite heavily.
It does. The classic case establishing this principle is Sotomayor v. de Barros,
Hmm.
number 2, decided way back in 1879. Remember Sotomayor v. de Barros, number 2.
Sotomayor v. Barros, number 2. Tell us about the facts.
This involved a marriage celebrated in England between first cousins. The husband was domiciled in England. The wife was domiciled in Portugal.
And the problem was,
Under Portuguese law, marriage between first cousins was prohibited. This was a matter of essential validity under her Portuguese domicile law.
so applying the general dual domicile rule, you would expect the marriage to be void because the wife lacked capacity under Portuguese law.
Precisely. That would be the logical outcome under dual domicile. But because the marriage took place in England, and the husband was domiciled in England, the court applied this specific exception,
And held the marriage. Yeah.
valid under English law. They completely ignored the fact that the wife lacked capacity under the law of her own domicile.
Academics like Cheshire, North, and Fawcett are quite critical of this exception, calling it xenophobic. Why such strong language?
Well, the criticism stems from the fact that it seems to prioritize English interests and standards for marriages taking place here over the personal legal status and restrictions that a foreign national carries with them from their own domicile. It effectively allows a foreigner to bypass their own domicile's marriage restrictions simply by marrying an English domiciliary in England.
Is there any defense of it?
Clarkson and Hill defend it somewhat, arguing that English law has a legitimate interest in regulating marriages contracted within its own jurisdiction and applying its own standards to maintain certainty here. Nevertheless, the Law Commission recommended abolishing this exception, seeing it as an anomaly and potentially unfair.
Okay, so that's a major exception to keep in mind for exams. Does the law of the place of celebration, lex loci celebrationis, have any other role in essential validity beyond just providing the location for this Sotomayor exception?
It's generally thought not to be the choice of law rule. There was a case, Breen v. Breen in 1964, which seemed to suggest that a marriage must also be essentially valid by the law of the place of celebration. But the source states that this aspect of the decision is universally criticized and contrary to authority in countries like Australia, Rees Swan's Will, and Canada, Reed v. Reed.
So generally, no.
However, it is acknowledged that if a marriage does take place in England, we would naturally expect it to satisfy English law's essential requirements domestically. For example, you couldn't validly marry a 13-year-old in England just because their foreign domicile law permitted it. English domestic public policy would likely step in.
Makes sense.
So, while lex loci celebrationis isn't the choice of law rule for essential validity generally, the domestic law of England as the place of celebration will apply if the marriage occurs here, in addition to the rules of personal law.
And finally, on essential validity, is there a public policy override here, just like we discussed with formal validity? Can England refuse to recognize a marriage valid under the personal law if it's just too offensive?
Yes. Even if a marriage is deemed essentially valid by the applicable personal law, under whichever test you apply, English courts can still refuse to recognize it if it is considered fundamentally repugnant to English public policy. However, and this is important, this discretion is used sparingly, very sparingly.
What's the key case illustrating the narrow scope of this public policy override for essential validity?
Cheney v. Cheney from 1965. Remember Cheney v. Cheney?
Okay, Cheney v. Cheney. What happened?
This involved a marriage in Cairo between an uncle and his niece. Both were domiciled in Egypt. Under Egyptian law, this marriage was valid.
But in England, marriage between an uncle and niece is prohibited. That seems like a strong candidate for public policy intervention.
You might think so. But the court, in Cheney v. Cheney, held the marriage valid and recognized it in England.
Why?
The reasoning was based on the principle of reasonable tolerance. This type of marriage, while not permitted in English domestic law, was acceptable under the party's Jewish law. They were Sephardic Jews, and also in some other Christian traditions historically. The court felt it wouldn't be justifiable or necessary to condemn such a marriage as unconscionable or against fundamental English public policy if it was acceptable to many people of deep religious convictions, lofty ethical standards, and high civilization.
So it's a high bar for repugnancy.
A very high bar. It wasn't just a matter of English domestic standards overriding foreign law simply because they were different, but only if the foreign rule was truly repugnant, at a fundamental level to English conceptions of justice.
Last point on essential validity.
Bro.
Does Renvoy play a role here?
Renvoy again. There is a decision, R.V. Brentwood, Superintendent Registrar of Marriages, XP Arias in 1968, that suggested Renvoy could apply here. However, the source points out that there are good reasons for excluding Renvoy in this area, citing Clarkson and Hill. So it's another point of debate, and perhaps less settled or likely to be applied than even informal validity. Probably best to assume it doesn't apply unless specific circumstances arise.
All right, pulling essential validity together. The governing law is the personal law, but which personal law is highly debated. Dual domicile is the main contender, but faces challenges from theories like intended matrimonial home, real connection, and the idea of a variable rule. There's a significant exception for marriages celebrated in England involving an English domiciliary, seen in Sotomayor v. de Barros, number 2, though this is criticized. Public policy can provide a narrow override, but only for truly repugnant cases, as shown in Cheney v. Cheney. And the role of Renvoy is uncertain, likely minimal.
That covers the general rules for the validity of, let's say, standard monogamous marriages. Now, we need to turn to a type of marriage that has historically posed unique challenges for English conflict of laws: polygamous marriage.
Right, and the starting point, the landmark case defining the traditional English view, is the very famous definition from Hyde v. Hyde.
Indeed. Everyone remembers the definition from Lord Penzance and Hyde v. Hyde in 1866. The voluntary union for life of one man and one woman to the exclusion of all others.
The classic definition of monogamous marriage in English law.
Exactly. And this definition led him to the original ruling in that case. A potentially polygamous marriage, being fundamentally different from this definition, could not be dissolved under English matrimonial law. The parties were not, in his view, entitled to the remedies of the matrimonial law of England.
So historically, for crucial purposes like divorce, polygamous marriages were simply not recognized by English courts. They were outside the system.
Correct. Hyde v. Hyde represented a position of non-recognition, certainly for matrimonial relief. However, the law has evolved significantly since 1866. Polygamous marriages are now recognized for many, although not all, purposes in England today.
Okay, so things have changed. Before we talk about recognition, how do we even decide if marriage is polygamous in the first place? By what law is its nature determined? Is it the place it happened or the people's home law?
That's a good question, and the source notes that this question hasn't been finally settled. One view, which has some case support, like Lee v. Lau, is a two-step process.
What are the steps?
First, you look to the lex loci celebrationis, the law of the place of marriage, to see what type of relationship is created according to that country's law. For instance, does it permit multiple spouses? Then second, the forum, the English court, classifies that relationship as either monogamous or polygamous, according to English law's understanding of those terms.
Can you tell us about Lee v. Lau? You mentioned it supported that view. Remember Lee v. Lau?
Yes. Lee v. Lau, decided in 1967, involved a marriage celebrated in Hong Kong under Chinese customary law. Under this law, a man could take sipsis, which were essentially secondary wives or concubines, in addition to a primary wife. The court held that this marriage was potentially polygamous, based on its incidence under the law of Hong Kong, the lex loci. This case supports the view that the place of celebration's law determines the characteristics, and then English law classifies.
Is there a counter-argument?
Yes. Contrasting with this, academics like Cheshire, North, and Fawcett argue that the fundamental nature of the marriage, whether it is inherently monogamous or polygamous, should properly be determined by the parties' lex domicilia, their personal law, at the time of the marriage. Cases like MVM in 2001 illustrate that this question of definition and classification can still be problematic in practice.
So there's still debate on whether the place of marriage or the party's home law at the time should determine if a marriage is polygamous from the outset. What about change over time? Can the nature of a marriage mutate? Can it change from one type to another?
Yes, mutability is an important concept here. A marriage that is initially potentially polygamous, meaning it was entered into under a law that permits polygamy, even if the husband hasn't actually taken a second wife yet, can change its nature and become monogamous in English eyes due to subsequent events or changes in law.
Can you give examples of this change from potentially polygamous to monogamous?
Certainly. We've already seen Cheney v. Cheney, the uncle-niece case. In that case, the birth of a child had the effect, under the relevant personal law, of rendering that particular potentially polygamous marriage monogamous.
Okay.
In Ali v. Ali, in 1968, a potentially polygamous marriage was deemed to become monogamous when the husband acquired a domicile in England, a country whose domestic law is strictly monogamous. Remember Ollie v. Ollie?
Change of domicile can trigger it.
Yes. And in Prakasho v. Singh in 1968, a change in Indian law which prevented the husband from taking any more wives had the effect of making his existing, potentially polygamous marriage monogamous in the view of English law. Remember Prakasho v. Singh?
Okay, so potentially polygamous to monogamous is possible due to events, changes in law, or change of domicile. But what about an actually polygamous marriage? If a man has two wives and one wife moves to England and gets an English domicile, does that make the marriage monogamous?
No. The source clarifies that an actually polygamous marriage cannot change to monogamous just by one wife changing her domicile. That was decided in Re Sahoda in 1978.
Right. What about the other way? Can a marriage that starts strictly monogamous become polygamous? That sounds potentially problematic.
This is a more complex and, for some, controversial area. Consider the facts of AG of Ceylon v. Reed from 1965.
Yeah.
Remember AG of Ceylon v. Reed?
Okay, A.G. Hassan v. Reed, what happened?
This case involved a man named Alan, who was domiciled in Ceylon, now Sri Lanka. He first married Edna in a monogamous Christian ceremony. They were married for 26 years. Then he converted to Islam and married Fatima in a ceremony valid under Muslim law, which permits polygamy in Ceylon.
So he tried to take a second wife while still married to the first.
Yes. The court in Ceylon held that his second marriage to Fatima was a valid polygamous marriage under the law of Ceylon. This meant he was not guilty of bigamy under Ceylon law, and the English Privy Council recognized that validity.
So from Alan's perspective, he was validly married to two women. What was the effect on the first marriage to Edna? Did that suddenly become polygamous too?
That was the critical question. The conclusion reached in Reed was that from Alan's perspective, yes, he was married to both. But the first marriage to Edna was not automatically transformed into a polygamous marriage from her perspective simply because Alan entered a second marriage.
How was her marriage viewed then?
The first marriage was held to remain monogamous from the point of view of the first wife, Edna, in order to protect her rights and status as a monogamous spouse. From her perspective, Alan was essentially committing adultery with Fatima, but her marriage remained monogamous. Nabi v. Heaton in 1981 is another case that illustrates this principle of protecting the first wife's status.
Protecting the first wife's monogamous status makes intuitive sense. Now let's turn to perhaps the most challenging issue regarding polygamy and conflict of laws today. The capacity to enter a polygamous marriage, particularly for someone connected to England.
Absolutely. This is crucial. Which law governs a person's capacity to enter into a marriage that is potentially or actually polygamous? As with essential validity generally, we can largely rule out the lex loci celebrationis.
So it's back to personal law, domicile or intended home.
Exactly. The core debate is between applying the law of the party's domicile at the time of marriage and applying the law of their intended matrimonial home.
And the prevailing academic view and support from legislative assumptions seems to favor the lex domicilii rule here, the domicile.
Yes, there is strong support for the idea that capacity to enter a polygamous marriage should be governed by the law of a party's domicile at the time of marriage. However, this area was significantly complicated by the controversial decision in Radwan v. Radwan, number 2, in 1973. This is a really important case.
Let's delve into Radwan v. Radwan number 2, because the facts were complex and the judgment influential despite the criticism.
They were very complex. The case involved Abdul, an Egyptian national domiciled in Egypt, who was already married to his first wife, Iqbal, under Egyptian law.
Okay, so he was already in a polygamous system.
Yes. He then married Mary, an English woman who was domiciled in England at the time of their marriage. This second marriage to Mary took place in the Egyptian consulate in Paris. The judge, Cumming Bruce J., held, somewhat surprisingly in the view of some commentators, that for legal purposes the place of celebration was effectively France, not Egypt, despite being in the consulate.
Okay, so an Egyptian man, already potentially polygamous under his domicile law, marries an English woman domiciled in England in France. Where did they intend to live?
They intended to settle in Egypt, and they did live there for about 5 years before moving to England.
And then?
They then lived in England for a further 14 years and had 9 children together. Abdul eventually acquired an English domicile himself.
So a long marriage, nearly 20 years, lots of kids. What happened then?
Abdul, who by this time had changed his name to Jean-Pierre, attempted to divorce Mary by talaq, a form of extrajudicial Islamic divorce. This was done at the UoL embassy in London.
Can you do that in England?
No. The judge held this was effectively done within England for these purposes, and under English domestic law, a talaq performed in England cannot dissolve a marriage. So Mary then petitioned for divorce in the English courts.
And Abdul's defense to the divorce petition was?
His defense was that they weren't actually married in the first place. He claimed that Mary, being English domiciled at the time of the marriage, lacked the capacity under English law to enter a potentially polygamous marriage.
So if the marriage was void, she couldn't get a divorce or financial orders.
Exactly. This is where the choice of law rule for capacity to marry polygamously became absolutely critical. If the court applied the standard lex domicili rule, Mary's domicile was England, and English domestic law doesn't allow people domiciled here to enter polygamous marriages. Her lack of capacity under English law would render the marriage void.
Which would have left her in a terrible position after 20 years and 9 children.
Precisely. But Cumming Bruce J. didn't apply the domicile rule for capacity here.
What did he apply instead?
He chose to apply the law of the party's intended matrimonial home to determine Mary's capacity to marry polygamously.
Which was Egypt.
Yes. Their intended home was Egypt, a country where polygamy was legal and accepted. By applying Egyptian law as the relevant law for this specific capacity issue, he found that Mary did have the capacity to enter a marriage which was potentially polygamous from Abdul's perspective.
And this saved the marriage?
It saved the marriage, allowing the judge to grant Mary a divorce and make vital ancillary orders for her and their 9 children.
It really sounds like the judge was stretching to find a way to achieve a just outcome for Mary after such a long relationship. The hard cases make bad law idea.
That is very likely the case, and the source acknowledges this motivation. However, the decision to depart from the more established domicile rule and apply the intended matrimonial home specifically for capacity to marry polygamously has been the subject of significant criticism from academics like Wade, Carson, and Cheshire, North, and Fawcett.
Why the criticism?
They argue it introduces undesirable uncertainty, potentially weakens the generally preferred domicile rule, and relies on the problematic intended matrimonial home doctrine. However, it also has some academic support from Clarkson and Hill, who see it as fitting within their broader argument for a variable rule tailored to the specific incapacity issue, polygamy capacity, being linked to the intended home.
So Radwan remains controversial but important. Given the controversy and the potential difficulties for people, particularly immigrants, navigating these rules, did Parliament step in to clarify things?
Yes, Parliament has enacted statutory provisions to address aspects of this area, partly in response to the complexities highlighted by cases like Radwan and the difficulties faced by immigrant communities. Firstly, we need to look at the Matrimonial Causes Act 1973, the MCA 1973.
Okay, what does the MCA 1973 say?
Section 11 of that act states that a marriage entered into outside England and Wales is void if it is a polygamous marriage, and either party was domiciled in England and Wales at the time of the marriage.
That sounds like a direct legislative statement preventing English domiciliaries from entering polygamous marriages abroad. Seems pretty clear.
It does sound clear, but like many things in law, it has to be read alongside Section 14.1 of the same act.
Okay, what does Section 14.1 do?
Section 14.1 states that Section 11, which contains the voidness rule in 11D, does not apply to the validity of a marriage if that validity is determined by a foreign law.
Okay, how does that interact with Radwan? This is getting technical.
It is technical. Think of it like this. Section 11D is a domestic rule saying certain marriages are void. It's not a choice of law rule telling you which law determines validity in the first place.
Right.
If the court applies the traditional lex domicili rule for capacity, and one party is English domiciled, then Section 11D kicks in and makes the potentially polygamous marriage void.
But what if the court follows Radwan?
If the court follows the approach in Radwan and applies the intended matrimonial home doctrine for capacity, and that intended home is in a country like Saudi Arabia or Egypt where polygamy is accepted, then the validity of the marriage is determined by that foreign law, Saudi or Egyptian law.
And then Section 14.1 applies.
Exactly. In that scenario, Section 14.1 is triggered, stating that Section 11 does not apply because validity is governed by foreign law. Thus, if the court applies the Radwan choice of law rule for capacity, the marriage can still be saved from voidness under Section 11D. The outcome of Radwan potentially survives the statute, depending on the choice of law rule used.
That's a very subtle interplay between the statute and the case law's choice of law rule. The source also mentions a more serious concern regarding the application of Section 11 to immigrant families. What was that about?
Yes, this relates to immigrants, or perhaps their children born and domiciled in England, who might return to their country of origin, say, Pakistan, and marry there in a ceremony that is legally, potentially polygamous under Pakistani law.
They might not intend to actually be polygamous.
Exactly. They might not intend to take multiple spouses, or even be aware of the strict implications of Section 11D for English domiciliaries marrying abroad in a form that allows for polygamy, even if they never intend to use that possibility.
How did the courts handle this potential hardship under the 1973 Act?
The key case is Hussein v. Hussein in 1983. Remember Hussein v. Hussein?
Okay, Hussein v. Hussein. Facts.
The husband was domiciled in England but married in Pakistan in a potentially polygamous form. His wife later petitioned for judicial separation in England, and he argued the marriage was void under Section 11D because he was English domiciled.
And the court said.
The Court of Appeal held the marriage was valid.
How did they reach that conclusion, given he was English domiciled and married polygamously abroad, seemingly falling right into Section 11D?
The Court of Appeal adopted a very specific, some might say creative, interpretation of Section 11D. They reasoned that an English domiciliary cannot enter an actually polygamous marriage because English domestic law, Section 11B of the 1973 Act, which prevents marrying again if already married, and the very definition of marriage in England only contemplate monogamy.
Okay, so.
Therefore, they concluded that a marriage could only be considered polygamous for the purposes of Section 11D if at least one spouse had the capacity under their personal law to marry a second spouse. If the man was English domiciled, he lacked that capacity under English law to take a second wife.
So because he couldn't actually be polygamous under English law, his marriage wasn't caught by the rule against English domiciliaries entering polygamous marriages abroad.
That was the essence of the reasoning. This interpretation meant that the marriage, from the perspective of the English domiciled husband, was not considered polygamous in the sense that triggered Section 11D, thus saving the marriage.
So, Hussein v. Hussein used an interpretation of capacity under English domestic law to narrow the scope of Section 11D and validate potentially polygamous marriages for English domiciled men marrying abroad. But the source identifies a gap still remaining after Hussein. What was the gap?
Yes. The reasoning in Hussein relied on the husband being the English domiciliary who lacked capacity for polygamy under English law. What if the wife was the English domiciliary? Her foreign domiciled husband could have capacity under his domicile law to take further wives.
So in that situation, the marriage would look potentially polygamous from the husband's side.
Exactly. In that scenario, from the perspective of English law, applying the husband's foreign capacity, the marriage would be considered potentially, or actually polygamous, and therefore potentially void under Section 11, based on the wife's English domicile. Hussein's reasoning didn't protect these marriages where the wife was the English domiciliary.
So Parliament had to intervene again to close that remaining gap. Seems like constant patching up.
It does feel a bit like that sometimes in conflict of laws. Yes, this led to Section 5 of the Private International Law, Miscellaneous Provisions Act, 1995, or PILA 1995.
PILA 1995, Section 5. What does it do?
Section 5 explicitly states that a marriage entered into outside England and Wales between parties, neither of whom is already married, is not void under English law simply because it is entered into under a law which permits polygamy and either party is domiciled in England and Wales.
That seems to directly address the problem left by Hussein v. Hussein for English domiciled wives.
It does. It means that a marriage entered into abroad is not void under Section 11D just because an English domiciled person was involved, whether husband or wife, provided it wasn't actually polygamous at the time, i.e. neither party was already married to someone else when they entered this marriage.
So it saves potentially polygamous first marriages for English domiciliaries.
Yes. This saves potentially polygamous marriages for both English domiciled men and women as long as it's their first marriage. It preserves the validity of these unions from Section 11D, though it doesn't validate marriages that are actually polygamous from the outset, like a man taking a second wife while domiciled in England. The Act also had retrospective effect, validating such marriages entered into before 1995.
Okay, so the journey of polygamous marriages in English law has gone from total non-recognition for matrimonial relief in Hyde v. Hyde to a complex system navigating definition, mutability, and capacity, with the debate around Radwan and the statutory interventions in MCA 1973 and PILA 1995. For what purposes are polygamous marriages actually recognized in England today? You said almost all purposes.
They are now recognized for almost all purposes, representing a significant shift starting really in 1972, with legislation allowing matrimonial relief.
Give us some key examples from the source material of where recognition is granted.
Okay. They are recognized for purposes of matrimonial relief, allowing wives in potentially or actually polygamous marriages to petition for divorce, judicial separation, or nullity in England. This directly overrules Hyde v. Hyde on this point.
Yeah. What else?
A potentially or actually polygamous marriage is recognized as a valid prior marriage that would render a subsequent monogamous marriage void on the grounds of bigamy. That's the principle from Baindale v. Baindale in 1946. Remember Baindale v. Baindale?
Makes sense. Children.
The children of such marriages are recognized as legitimate, as established in the Sinha Peerage Claim in 1946. Remember the Sinha Peerage Claim?
Inheritance.
Yes. Spouses are entitled to succeed to most types of property in England, with only limited exceptions for things like entailed interests or titles of honor, as shown in Bangbos v. Daniel in 1955. Remember Bangbos v. Daniel? Spouses qualify under intestacy rules. Coleman v. Shang in 1961, remember Coleman v. Shang? And a wife can qualify for financial provision under the Inheritance Provision for Family Independence Act, 1975, illustrated in Res Judicata in 1978. Remember Res Judicata, we saw it for mutability, too.
Any others? Tax. Immigration.
Yes, polygamously married wives are recognized for income tax purposes. Nobby v. Heaton in 1983, another case we've seen before, and they are recognized for deportation purposes under the Immigration Act, 1971.
So almost all purposes really is quite extensive. Are there still specific areas where recognition is denied? Any notable exceptions?
Yes. The source notes a few key exceptions. Rights to a widow's pension under the state Social Security scheme are generally denied, as seen in RV Adaptive Health XP Misra in 1996. Remember Misra?
Okay, state pensions. Anything else major?
And for immigration purposes, recognition is largely denied, particularly if a second wife seeks to enter the UK while another wife of the same husband is already present and settled here. That's under Section 2 of the Immigration Act 1988.
Right, immigration remains restrictive. So polygamy is a complex area, moving from historical non-recognition, Hyde, to broad recognition today, but with intricate rules around definition, Levy-Lau, mutability, Cheney, Ali, Parkasho, Reed, and especially capacity, involving challenging case law like Radwan and specific statutory interventions, MCA 1973, PILA 1995. And recognition isn't quite total.
It certainly illustrates the dynamic nature of conflict of laws in adapting, sometimes awkwardly, to different social and legal structures encountered internationally. Let's briefly turn now to another evolving area, same-sex marriages.
This is a much more recent development in domestic English law, which has naturally had implications for conflict of laws, hasn't it?
Absolutely. Traditionally, English law, like many legal systems globally, defined marriage exclusively as a union between a man and a woman. Same-sex relationships were not recognized as marriage.
But that changed.
Yes. This began to change significantly in the UK, first with the legalization of civil partnerships under the Civil Partnership Act 2004. Then, crucially, with the Marriage, Same-Sex Couples Act 2013 for England and Wales, which came into effect in March 2014, legalizing same-sex marriage.
And Scotland and Northern Ireland followed.
Yes, Scotland followed quite quickly in December 2014, but Northern Ireland much later, only in January 2020.
What were the key provisions introduced by the 2013 Act for England and Wales that are relevant for our conflict of laws discussion?
Well, Section 1 of the Act simply made marriage between same-sex couples lawful in England and Wales. And critically for conflict of laws, Section 11(1) states that in the law of England and Wales, marriage has the same effect for same-sex couples as it does for opposite-sex couples.
Equality in effect.
Yes. And Section 11(2) ensures that other relevant English and Welsh laws apply accordingly. A major consequence was that same-sex couples who had married overseas in countries where it was already legal and who were previously treated only as civil partners in England and Wales are now recognized as being married here.
So overseas marriages were recognized retrospectively, in effect.
Yes, their status was updated. The Act also introduced provisions allowing couples in civil partnerships to convert their relationship into a marriage and enabling married individuals to change their legal gender without having to annul their marriage.
So domestically, same-sex marriage has broadly equal standing with opposite-sex marriage now. Are there any remaining differences noted in the source?
A few are noted. For religious ceremonies, the religious organization must explicitly opt in to perform same-sex marriages. Notably, clergy of the Church of England and the Church in Wales are prohibited by the Act from conducting them.
Okay, religious opt-in. What about divorce grounds?
Adultery is not available as a ground for divorce in same-sex marriages, though unreasonable behavior, desertion, etc. still apply. Nullity on the grounds of non-consummation is also not available for same-sex couples.
And pensions.
Yes, there remains a difference regarding occupational pension survivor benefits. Providers are only required by law to provide benefits based on contributions from December 5, 2005, the date the Civil Partnership Act came into effect, which can be less generous than for opposite-sex couples whose contribution history goes back further.
Right. Some technical differences remain. How does English law now recognize same-sex marriages performed overseas? What are the conflict rules?
Section 10 of the 2013 Act is explicit on this point. An overseas marriage is not prevented from being recognized under the law of England and Wales simply because it is between a same-sex couple.
So being same-sex is not a bar to recognition in itself.
Correct. Recognition is determined according to the usual private international law rules that we've been discussing for marriage validity generally.
So the marriage must be formally valid by the lex loci celebrationis, and the parties must have had capacity under their personal law, the same rules as before.
Exactly. Those core rules apply. The marriage must comply with the formal requirements of the country where it took place, lex loci celebrationis. And both parties must have had the essential capacity to enter that marriage according to their personal law, which usually means their law of domicile.
Is the Sotomayor exception relevant here?
Yes. The source notes a modification mirroring the principle from the Sotomayor exception for marriages celebrated in England and Wales. For same-sex marriages celebrated in England or Wales, only one party needs to have capacity according to the law of their domicile for the marriage to be essentially valid here, at least as regards potential incapacity under the other party's foreign domicile law.
Okay, so the same special rule applies for marriages on English soil. The Act also required reviews into some related areas.
Yes, briefly, the Act mandated reviews into allowing belief organizations like humanists to conduct legal ceremonies for same-sex couples, the future of the Civil Partnership Act itself, now that marriage is available, and those differences in occupational pension survivor benefits. These areas may see further development.
So, in summary for same-sex marriage, English law has undergone a rapid and significant shift from non-recognition to legality and broad equality, with opposite-sex marriage domestically, with limited exceptions remaining. Overseas same-sex marriages are recognized in England based on the standard conflict of laws, rules for formal validity, lex loci, and essential validity, personal law domicile, with that specific Sotomayor-style rule protecting marriages celebrated on English soil.
That covers adult relationships. The final section we need to tackle focuses on the legal status of children, particularly the concept of legitimacy, from a conflict of laws perspective.
Right. And as we mentioned earlier, the concept of illegitimacy has fortunately lost much of its significance in modern English domestic law, with legislation removing most of the disadvantages previously faced by children born outside of marriage.
That's certainly true domestically. However, the concept of legitimacy can still be highly relevant in a conflict of laws context. For instance, a will, whether governed by English law or a foreign law, might make a bequest specifically to legitimate children. In such cases, an English court might need to determine if a child, perhaps born or adopted overseas, or of parents with foreign connections, is considered legitimate according to the relevant conflict of laws,
Right.
rules, to see if they inherit.
Okay, so it still matters for things like succession. And trying to determine legitimacy by looking at personal law, like domicile, seems to immediately run into a problem, doesn't it? The source mentions a vicious circle.
It does. It creates a classic conflict of laws, vicious circle. Domicile of origin, which is a key connection point for personal law itself, depends on legitimacy.
How?
Generally, if a child is legitimate, their domicile of origin is usually their father's domicile at the time of their birth. If they're illegitimate, it's usually their mother's domicile. So how can you apply the law of the domicile to determine legitimacy when you need to know if the child is legitimate in order to determine their domicile of origin in the first place?
Right. The definition relies on the very thing you're trying to define. You need the answer before you can ask the question properly.
Exactly. One proposed, though somewhat arbitrary and historically rather sexist, solution mentioned is simply to cut the circle and say legitimacy is governed by the law of the father's domicile at the date of birth. But the case law in this area is complex and, frankly, quite conflicting.
And the source highlights a leading and troubling case here, Shaw v. Gould. That sounds ominous.
Yes, Shaw v. Gould from 1868 is often cited as the traditional starting point, but it's problematic. Remember Shaw v. Gould. Its strict holding was that legitimacy depends solely on the validity of the parents' marriage according to English conflict rules. A child was considered legitimate only if they were born into what English law considered lawful wedlock.
So, under Shaw v. Gould, if the parents' marriage was somehow invalid, according to the relevant conflict of laws rules, say invalid by the applicable personal law for essential validity, their children would be deemed illegitimate in England.
Yes, even if they were considered perfectly legitimate under some other potentially relevant law, like law of the child's birthplace or the parent's domicile at birth.
Exactly. And as academics like Cheshire, North, and Fawcett, cited in the source, strongly critique, the issue is the status of the children, not of their parents.
That seems fair.
They argue it is fundamentally flawed to make a child's status entirely dependent on the validity of their parents' relationship under a potentially complex choice of law rule. It could leave children illegitimate in England, even if universally recognized as legitimate elsewhere. The source directs readers to Cheshire, North, and Fawcett for a detailed account of this criticism.
So Shavi Gold is a key case,
Yeah.
but heavily criticized for focusing on the parent's marriage rather than the child's status directly. Did later cases offer an alternative approach?
Yes, thankfully. There was a different approach taken in Re-Bischofsheim in 1948. Remember Re-Bischofsheim?
Read Bischofsheim.
Look at it hold. This case held that a child was legitimate if they were legitimate by the law of the domicile of both of their parents at the time of their birth, even if the parents' marriage wasn't considered valid under English conflict rules. This decision directly challenged the strict principle from Shavi Gould.
So it focused on the child's legitimacy under their parents' law, not the marriage validity.
Exactly. It shifted the focus.
Did subsequent cases follow Red Bischofsheim's approach?
Yes, the approach in Rebbe-Shosheim has been followed in later cases, such as Motala v. AG in 1990. Remember Motala v. AG?
What happened in Motala?
In that case, concerning claims to British citizenship, children born of a marriage that was void under the local law in Northern Rhodesia were nevertheless held to be legitimate in England. Why? Because they were legitimate by the law of India, which was both their domicile of origin and their parents' domicile at the relevant time.
So we have this clear conflict in the cases. Shavi Gould, linking legitimacy solely to the parent's marriage validity, versus Reb Bischofsheim and Motala v. AG, linking it to the child's legitimacy under the parent's, or maybe father's, domicile. Which approach is considered more authoritative today?
That tension persists in the case law. It's not fully resolved. However, Hashmi v. Hashmi in 1972 suggests that where parents have different domiciles, the child's legitimacy can be determined just by reference to the father's domicile alone at the date of birth. Remember Hashmi v. Hashmi.
Okay, father's domicile as a potential decider.
And the academic argument, particularly from Cheshire, North, and Fawcett, is that the strict rule in Shaw v. Gould should really be confined to its particular facts, and that cases like Re-Bischofsheim and the rules on legitimation, which we'll discuss next, actually support the rule that a person is legitimate if they are considered legitimate according to the law of their father's domicile at the time of the child's birth.
So father's domicile at birth seems to be the academically preferred rule, despite the lingering problematic authority of Shaw v. Gould.
That seems to be the direction of travel, yes. What about foreign legitimations, where a child is born illegitimate under the relevant law but later becomes legitimate? How does England recognize that?
This is the process of legitimation. The most common way this occurs is through the subsequent marriage of the parents after the child's birth. English law, specifically the Legitimacy Act 1976 Section 2, recognizes a foreign legitimation by subsequent marriage.
What's the rule under the Act?
It's recognized if the father was domiciled in the foreign country at the time of the marriage. Crucially, under the 1976 Act, you do not need to show that he was domiciled in that country or any country that permitted legitimation at the time the child was born. Just his domicile at the time of the marriage matters.
So if a father was domiciled in country A when the child was born, illegitimate, later moved to country B, and then married the mother while domiciled in country B, and country B's law allows legitimation by subsequent marriage, that legitimation is recognized in England.
Yes, under the 1976 Act, provided the father was domiciled in country B at the time of the marriage. The law of his domicile at the date of the child's birth is irrelevant for legitimation by subsequent marriage under this act.
Okay, that seems relatively straightforward for subsequent marriage. Are there other ways for a child to be legitimated in foreign law besides subsequent marriage, like formal recognition?
Yes, some countries allow legitimation by things like formal parental acknowledgement or by court order or even by operation of law without a specific act. The facts of Relux Settlement Trust in 1940 involved legitimation by acknowledgement under the father's foreign domicile law. Remember Relux Settlement Trust?
Does the 1976 Act cover these other methods?
No. The Legitimacy Act 1976 only covers legitimation by subsequent marriage.
So how does English law deal with these other methods of legitimation then? Acknowledgement, court orders, etc.?
The common law rule applies, often by analogy from older cases, as seen in Relux Settlement Trust. And this common law rule is significantly stricter than the 1976 Act rule for subsequent marriage.
How is it stricter?
It states that legitimation by means other than subsequent marriage, like acknowledgement, is recognized in England only if it is effective by the law of the father's domicile at the date of the child's birth. A and D also effective by the law of the father's domicile at the date of the acknowledgement or other act that purports to legitimate the child.
So a double domicile test, the father's domicile, must permit that method of legitimation both when the child was born and when the legitimating act occurred. That's a much higher hurdle than the 1976 Act rule for subsequent marriage.
Exactly. It's much harder to satisfy. This can lead to complex situations where a child legitimated by acknowledgement under a foreign law is not recognized as legitimate in England if, for example, the father changed his domicile between the child's birth and the acknowledgement, and the law of his domicile at the time of birth didn't recognize legitimation by acknowledgement. Relux Settlement Trust itself is an illustration of the complexities and potential unfairness this stricter common law rule can create.
Okay, so to quickly recap on legitimacy, the concept is still relevant in conflict of laws despite fading domestic importance. The rule for determining initial legitimacy is complex, with conflicting case law between Shaw v. Gold, based on parents' marriage validity, and Ray Bischoff Shaimatala v. AG, based on legitimacy under parents' or father's domicile, with academic support favoring the father's domicile at birth rule. For foreign legitimations, the rule depends on the method. Legitimation by subsequent marriage is recognized if valid by the father's domicile at the time of the marriage under the 1976 Act, while legitimation by other means, like acknowledgement, Relux Settlement Trust, requires validity under the father's domicile at both the date of birth and the date of the legitimating act under the stricter common law rule.
That covers the key points on legitimacy and legitimation.
We've certainly covered a substantial amount of ground today, navigating the intricate rules English law applies to formal and essential validity of marriage,
Thinking about lex loci celebrationis versus personal law.
how it has evolved to grapple with the complexities of polygamy from Hyde v. Hyde to Radwan and the statutes,
And the newer landscape of same-sex marriage following the 2013 Act.
and finally, how it determines the status and legitimation of children when different legal systems are involved, with cases like Shaw v. Gould and Re Bischofsheim.
It's absolutely vital to grasp these rules, understand the policy reasons behind them where possible, and know the key cases that illustrate their application, interpretation, and importantly, the debates they've generated.
Yes, remembering those case names is key for exams.
Remembering cases like Apt v. Apt and Berthiaume v. Dastis for lex loci celebrationis and characterization, Starkowski v. AG for retrospective validation, the controversial Tatsanowska v. Tatsanowski for exceptions.
The different tests for essential validity, the Sotomayor v. de Barros No. 2 exception, the limits of public policy, and Cheney v. Cheney.
The historical journey from Hyde v. Hyde for polygamy, the capacity debate involving Radwan v. Radwan No. 2, and the statutory interventions in MCA 1973 and PLA 1995.
The recent changes for same-sex marriages.
And the conflicting approaches to legitimacy in Shaw v. Gold versus Ray Bischofsheim, and the rules for foreign legitimations from the 1976 Act and Relux Settlement Trust. These are all key building blocks for understanding this area.
Absolutely. Understanding these conflict of laws principles is crucial for anyone dealing with international personal relationships legally. And it's certainly essential if you're preparing for exams on this topic. As you review these rules and cases, maybe take some time to consider the difficult questions they raise.
For instance, reflect on that problem of retrospective laws we discussed. We saw that retrospective validation by the lex loci celebrationis is generally accepted under the Starkowski principle. But the source suggests retrospective invalidation by a foreign law might be refused on public policy grounds.
Exactly. So here's a thought to leave you with. If a marriage was perfectly valid when celebrated according to the law of that place at that time, but years later, that foreign country passes a law that retrospectively says, actually, any marriage entered into by a foreigner like that is now void, should English law recognize that invalidation? Why or why not?
Think about the principles at stake. Is it more important to protect the status and rights acquired under the law as it was when the marriage took place? Or should we recognize the current legal reality in the country concerned, even if that reality is a retrospective change that seems unfair?
And consider the role of public policy here. When should it step in to block the application of foreign law? When does a foreign law become truly repugnant?
It's a challenging hypothetical that forces you to weigh competing principles in conflict of laws, vested rights versus comity, certainty versus flexibility, fairness versus sovereignty, keep thinking about these scenarios.
Keep reviewing the cases, the principles, and the statutory provisions. And once again, good luck for all of you for the exam.
Yes, best of luck.
Thank you for joining us for this deep dive. We hope it's been helpful in making these complex rules a little clearer and perhaps more memorable.